issue that goes to the heart of our constitutional democracy. Is the Supreme Court opinion of this 5-judge bench to be treated as a judgment or an advisory? Should there really be timelines for presidents and governors to give assent to bills, or can they just sit on legislation? Will the Supreme Court ruling create more confusion? Is this a setback for the basic concept of federalism? Will governors' powers now only expand? Joining me now, Satyapal Jain, Additional Solicitor General, Justice Gyan Sudha Mishra, former Judge of the Supreme Court, and Dushyant Dave, Senior Advocate, Supreme Court, joins us at the moment. Mr. Dave, your first reactions. You heard Mukul Rohatgi saying Ambedkar would turn in his grave. Looking at this judgment, he claims Ambedkar believed governors would not be biased, but in an era of partisan governors, you need some checks and balances. Do you agree that timeline should have been set by the court? Governors cannot sit endlessly on legislation.
Rajdeep, first and foremost, I think this whole approach in filing this petition for review or a presidential reference was absolutely improper. If the government was upset with the judgment of the 2-judge bench headed by Justice Partisan and Justice Mahadevan, they could have filed a review. They could have then gone for a curative. But to come through backdoor like this and seek an opinion, which opinion, as Mr. Rohatgi rightly said, is not binding on anyone, makes no sense to me. Having said that, I must say that the opinion has thrown out the parliamentary democracy out of the window. It is something which is completely unacceptable. I mean, it is really surprising that the 5 learned justices have, interpreted the Constitution in such a narrow sense. Because ultimately, what is a bill? A bill in a state legislature is the will of the people. They have elected this legislature, the majority party. They have majority party has now formed a government, and majority party has now piloted a bill. And that bill now is awaiting the assent from the governor. He can't sit over it even for a day or two.
What happens if the bill is bad? What happens, Mr. Dave, according to you, if the bill is bad in law? If it is seen to be prima facie a bill which is not as per the constitution of the country. According to the court, they are separating constitutional authorities. Governor's role, executive's role, legislature's role, court's role, all are being separated.
No, governor has no power to decide the merits of the bill. Whether it's constitutional or not, whether it is right or wrong, that's in the realm of the judicial review. And whoever is aggrieved by that bill has a right to challenge it. At the most, governor can send it back to the assembly for reconsideration. If assembly on reconsideration says that we accept this bill, then that's the end of the matter. In a given situation, governor has a power to send the bill to the president for advice. But governor must act, and he must act as soon as possible under Article 200. So as soon as possible words have been completely lost sight of by the 5 learned judges. It means immediately. I mean, if English language is so clear. So I personally feel that, this judgment is frankly, one is not surprised at the judgment, because today, judiciary is quite soft on the executive. But you look at, this concept has been considered by Supreme Court earlier in the past in some Singh and other cases, where Supreme Court said that governor is only a figurehead and that governor must act in constitutional sense. Now, if he has to act in constitutional sense, he cannot forget for a second that he is not the elected representative. He is not, some kind of a monitor. He is only there to, be a link between the center and the state. That's all. So I feel that, the theory of checks and balances has been completely lost sight of. The Supreme Court has not only power, but duty to act. And having failed to act, if this opinion were to be, converted in tomorrow into a binding judicial decision, it would really be travesty of the justice. It will really make mockery of the Constitution. Constitutionalism.
Okay. You're using also very strong words that you fear that this judgment could make a mockery of the Constitution. Satyapal Jain, you want a quick response, and then I'll go to the judge. But Mr. Jain, the fact is that there was a 2-judge bench which clearly laid out timelines based on the fact that the Tamil Nadu governor had sat for more than 2 years on bills. I mean, if you have governors sitting on bills for 2 years, it is a recipe for a potential flashpoint and a constitutional breakdown.
See, in my view, the judgment delivered by the Constitution bench of the Supreme Court today is a very balanced judgment, balanced advice. It realizes the powers conferred on three different constitutional authorities of the country as envisaged by the Constitution of India. Let's not undermine the role of the governor simply to a rubber stamp. I'll just remind my friends, then all other functionaries, minister, MP, judges take oath in the name that they will owe allegiance and faith to the Constitution of India. But when the governor takes oath, Article 159, I'll just read one line. He says, and will do the best of my ability, preserve, protect, and defend the Constitution and the law that, and I will devote myself to the service of the people. He is supposed to preserve, protect, and defend the Constitution. So
But
therefore,
he's
it is the
also supposed to
constitutional
act on
obligation.
the aid and advice of the Council
Yes.
of Ministers.
See, aid and advice has also been clarified by the Supreme Court. Aid and advice is in a limited extent. So far as the constitutional matters are concerned, bills are concerned, if he was to act only on the aid and advice of the governor of the government, then what was the need of this oath? 159. What was the need of provision? Three provision in Article 200 of the Constitution of India, which gives three options to the governor. See, let's not undermine the role of the governor simply because some governor has been sitting over some issue for 1 year or 2 years. Nobody can justify that. I'm not going into that. The judgment says very clearly, number one, the governor is a constitutional authority. Powers have been vested in him under Article 200. The oath part 159 has not been discussed in the Supreme Court, which I am pointing
Right.
today. They have preserved his right. If there is a delay, unnecessary delay, the Supreme Court has opened the way, kept the window open, that somebody can come to the court. Court cannot examine the wisdom of the governor. Cannot. This is what the judgment says. But in case
So
there is
the
a
court,
the office of the governor is not immune. So it's a very
okay,
balanced judgment which
you're
gives
calling
power
it a
within their
balanced
own
judgment.
field to all
Others
the
are
authorities.
saying it's a mockery of the law. Two very clear
not
viewpoints.
at
I
all.
want to bring you Justice Gyan Sudha Mishra. It's an unusual situation, ma'am. You're a former judge of the Supreme Court. You've got a situation where a two-judge bench made it very clear there must be timelines before for any bills that are kept pending or withheld by a governor or president. You can't just indefinitely sit on bills. Now you've got the Supreme Court saying, no, we don't want to get into setting timelines for president and governors. They are constitutional authorities. We don't want to clash with them. Is there a balanced view, according to you, that the five-judge bench has taken, or are they effectively creating even more confusion?
The Constitution Bench judgment, in my view, is impeccably a balanced verdict that I, as a judge, could ever conceive of. It has diluted the extreme view that was taken by the two-judge bench, and it has given an absolutely balanced view that the judge, the governor cannot sit on the bills indefinitely, because you see, when the constitution, because there are situations when a legislation is enacted and the constitution was framed, one would never conceive of an extreme situation where the constitutional authority uh, would in some sense act beyond the boundaries without being conscious of the reasonableness of their action. But at times,
But ma'am, with due regard, you're looking at at a perfect situation. What is the reality? The reality is, particularly governors in opposition-ruled states are in constant conflict with those state governments. In that situation, if a bill is being withheld, even though it's been passed by the legislature, should the court not intervene and set some kind of a reasonable timeline? How do you define a reasonable timeline?
Of course, that's a very tricky situation. But you see, whenever a situation of a complex nature or a complicated nature arises, I think the water seeks its own level is applicable to all institutions, including the courts. And when it is left open, even in the by the Keshwanand Bharti case, that even the basic features of the constitution can be subject to judicial review, then that constitution, this governor also is a part of the constitution and is the constitutional authority. So it is very difficult and rather impossible to list that what are the situations and what would be the timeline for the governor to act
But
to give
okay,
the consent.
so we've
So
got two of my guests saying it's a balanced judgment. Dushyant Dave, not for the first time, you're the outlier. But I just want to understand from you, therefore, look at it from the Supreme Court's point of view. They seem to have taken a step back because they fear that if they set timelines, they will effectively find themselves in an adversarial position vis-a-vis the executive potentially, or indeed the president or the governor. So they are playing safe. They don't want to rock the boat at the moment and create a confrontation, adversarial situation by saying, no, you have only 3 months to decide on a particular bill.
I think the judges, in a lighter vein, are trying to, protect themselves, because, as we all know, that judges across the board, Supreme Court, High Courts, and trial courts, take their own time in delivering judgments. Sometimes years after they have heard the matters, by which time they have forgotten what was really argued before them and what was the matter about. But anyway, having said that, let me say one thing: that the Article 200 is expressly clear. It only gives the option to the governor to either assent or to return as soon as possible. Now, if this is not a mandate, then what else is the mandate? You cannot, Mr. Jain is, with great respect, completely wrong in relying upon the oath. The Supreme Court judges also have a constitutional oath to uphold the Constitution. Their duty is to ensure that checks and balances are maintained between the executive, legislature, and they don't cross their path. That's the role of the judiciary. Judicial review of the executive action is the basic structure of the Constitution as per Supreme Court. Now, if therefore the governor, does not act, then is it expected that everybody should sit, waiting for the governor to clear? After all, every political party wins elections on the basis of their manifesto, their promises to the electorate, which are then many a times translated into, legislative bills, so that
Right.
those promises are fulfilled. Now, if governor were to sit for 2 or 3 or 4 years, that promise cannot be fructified, and the electorate will feel disappointed. So I think this is completely bizarre, absurd argument that governor can take his own time. No, governor is not imperium in imperio. He is under the Constitution. He is under the law, and he is
Okay.
therefore bound. He is therefore bound to act as per the principles of Constitution and constitutionalism. He cannot
I,
just become a knight errant, as we have seen.
you see,
They are
therefore, I take your point. You see, Satyapal Jain, the court is saying governor is not a rubber stamp, but neither can the governor act in a hyper-partisan way against the basic tenets of the Constitution, wherein legislatures are seen to be the will of the people. But that's exactly what's happening. You see, it's not just one Tamil Nadu. There are several cases in recent times where governors have sat on bills. West Bengal has seen it, Kerala has seen it, different opposition-ruled states have seen it. Therefore,
See, this
should
is-
the court not have shown more courage and in a way
This is what
put
the
out a
Supreme
more
Court
courageous
says.
judgment? Is this a very soft judgment?
Rajdeep, no.
What you're
Supreme
saying is
Court has
balanced,
clarified
critics will say
exactly-
soft.
Supreme Court has clarified exactly the point that you are raising now. Supreme Court has kept a balance between all. The governor cannot sit indefinitely. The Supreme Court says so. And if he does it, somebody can come to the court of law. I give one example. Tamil Nadu is one extreme example. In case of Himachal Pradesh, the Himachal Vidhan Sabha passed an act about the appointment of the vice chancellors against the regulations of the UGC, against the Supreme Court judgment that the governor will choose one out of the panel prepared by the search and selection committee. The governor calls the CM, discusses with him, and they pass the bill again, which is against the constitution. In Punjab, when Banwarilal Purohit was the governor, certain bills were passed by the Punjab Vidhan Sabha, which were totally
Right.
against the constitution. The Punjab Vidhan Sabha passed a resolution condemning the certain concession given by the union government to the employees in Chandigarh. When Captain Amrinder was the Congress High Chief Minister, they passed a bill cancelling all the agreements enacted by the state earlier. So there
Okay.
are certain situations where the governor has to apply his mind and to protect, preserve, and defend the constitution. He
I'm going
needs
to leave
time.
it.
to think over it.
I'm going to, we've heard two very clear points. Justice, you want to say something to the lawyers, ma'am? Is there a word you would say? Judges now find each of their comments being discussed on social media, being targeted. Does that make life of a judge more difficult?
I think it's for the sitting judges to take the call on this question, because we were at a time when there was no social media. So we were largely protected. But yes, I think when we take oath, when the judges take oath to be dispassionate, then being, by a, I would say, disgruntled elements, they go to the extent of, I don't know, mudslinging and chappal slinging and whatnot. So, but fortunately, the lawyers with experience and whether I should be saying in substance, because they also act objectively and dispassionately, they fortunately they don't go to that extremes, and that's a very fortunate sign. And
So the operate. So I think at the end of the day, judgments need to be debated without necessarily personal allegations being made. But judgments do need to be debated. Judges are not above the law, and neither should be governors in this country. No one should be above the law, and hopefully the
Constitution
Supreme
is
Court
supreme,
judgment,
not
rather
anybody
than give
individual.
immunity
Rule
to
of law is
judges,
supreme.
rather than give
Constitution is
immunity
supreme.
to governors, must send out a much stronger signal to governors. That's the hope, and umeed pe duniya kayam hai. I appreciate my guests joining me here on my big talking point.